The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 25th of May, 2016, are currently trading with gold at $1,224.24 an ounce, silver $16.29 an ounce, Texas crude $48.62 a barrel, and Bitcoin is currently sitting at about 449 U.S. currency. Today in history, the year 1961, John F. Kennedy announces the U.S. government's goal of putting a man on the moon before the end of the decade, though many point out that a funny thing happened on the way to the moon, with NASA essentially staging the whole thing. John F. Kennedy announced the plan for America to aim for the moon. Today in history. In recent news, Hillary Clinton, former head of the State Department and current Democratic presidential frontrunner, was highly criticized in a report released today by the State Department's independent investigator, stating that her email practices while running the department were not the smartest. It states that her use of private email for public business was not an appropriate method of preserving documents, concluding that her practices failed to comply with the department's policies meant to ensure that federal record laws were followed. Apparently, a better option would have been for her to have printed and saved her emails during the 4 years in office and immediately comply with turning in her work-related correspondence upon stepping down in February of 2013, instead of sitting on those records nearly 2 years. If this isn't bad enough, the report noted that a top Clinton aide was warned in 2010 that the system may not be properly preserving records, but they dismissed those worries, indicating that the system passed legal requirements, even though the Inspection General uncovered that it could not show evidence of a review by any legal counsel whatsoever. Keep in mind that this independent State Department investigation releases a report in the midst of the current FBI investigation into whether Clinton mishandled classified material through her use of a private server in her New York home. Texas is set to become the first state to sue the Obama administration over the new federal guidance for transgender students in public schools. Governor Greg Abbott tweeted today that Texas will sue, quote, to stop Obama's transgender directive to schools. The message from his personal Twitter account came hours before a scheduled news conference by State Attorney General Ken Paxton. Several states have vowed defiance since federal officials this month told U.S. public schools to let transgender students use bathrooms and locker rooms to match their gender identity. The Lone Star Lowdown is currently looking for sponsors. If you have a product or a service you'd like to advertise with us, feel free to give me a call at 210-363-2257. This has been Rick Rohde with your Lowdown for May 25th, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? Okay. Howdy. This is Randy Kelton, Deborah Stevens, We Live Law Radio, except we're here with Mr. Eddie Craig tonight. He's kind of lurking back there in the background, producing the show for us. And he may chime in a time or two because I'm going to start out talking about his favorite subject, tickets. I got a ticket a while back for my registration being expired. And it's about 2 o'clock in the morning. I dropped my wife off at work, and I guess he was bored. And he wrote me a ticket just because my registration was about 6 months out of date. And I told him at the time, I said, you're going to love this. I'm going to give you a romp through the legal system you are not going to believe. So let me start out by examining the ticket. The ticket, it describes me vaguely. It gives an address, describes my vehicle, the location, and the citation is expired registration. Now look that up. I did a search for expired registration. Went on Google and Texas expired registration. I got 0 hits. I couldn't find any code named expired registration. So I don't know what the heck that is. Now I can guess as to what it is, but this is not a game show. This is law. And also, there's nothing on this document establishing jurisdiction. And then when I read the bottom of it, he had me sign it. And I signed it, and I agreed to show up by 4:30 p.m. on May the 12th. Well, I showed up before that and asked to see a magistrate. Well, when I got there, the clerk said, can I help you? And I told her, yeah, one of your dirty, rotten coppers wrote me a ticket. Oh, he did? Well, that's terrible. Well, what they write you for? I said, expired registration. She said, was your registration expired? I said, yeah, but only about 6 months. She said, well, that dirty rascal. Did you get it up to date? No. Well, if you get it up to date, we'll just charge you $20 and drop the whole thing. I said, I know. Well, Ms. Kelton, are you going to get it up to date? No. Well, then we need you to plead. No. I'll avoid that part. Here I have this motion to file with the court instead. She said, well, you have to plead. I said, no, don't. Well, if you don't plead, the judge will plead for you. I said, I don't care what the judge does. I got this motion to file. So they took my motion and 2 information requests. The information requests turned out to be the most fun. Let me dig them out here and read them to you. And I've been sending these out to anybody who's asking for them. They may need a slight adjustment. They're on my standard, extremely obnoxious open government request you can find on jurisprudence.com. And the meat of the document is, I want to see a complete list of all training provided for Decatur peace officers intended to ensure compliance with the requirements for authorization to enforce the transportation code and as contemplated by 6.44101 and 701.001. And then I have a second one that says evidence of authority to enforce the provisions of the Texas traffic law. Chapter 644, for all officers so authorized in the city of Decatur. Those are 2 separate requests. Well, the chief of police knows me. We've had some encounters in the past, most of them positive. And this is the gist of his answer. You requested a complete list of all training provided for Decatur peace officers intended to ensure compliance with the requirements for authorization to enforce the Texas Transportation Code as contemplated by 644.101 and 701.001. The gist of his answer is the city of Decatur does not comply with this code due to not meeting the requirements under the law and do not enforce the commercial motor carrier laws. Therefore, we cannot provide you training on this code that we do not enforce. Oh, that was great fun. Eddie, what do you think about that one?
We don't enforce this code except for when we're committing fraud by enforcing this code and writing you a ticket.
So I got my dates screwed up. I was so looking forward to going to this hearing because when I read the ticket to you, it said I was supposed to appear on or before the 12th of May, which I did, and asked the magistrate, and they said there wasn't one there. Well, they sent me this notice to appear. But the notice to appear is not only is it not signed, it doesn't have a place for anybody to sign it but me. Or, I'm sorry, it has a place for a parent or legal guardian to sign it. I could get my parent to sign it, but she would forget the next day. She's 93. And it doesn't tell me why I'm required to appear. And this went in line with a challenge to subject matter jurisdiction that I filed. One of the issues in a challenge subject matter jurisdiction is, it's not in the challenge subject matter jurisdiction, issue concerning arraignment. Actually, I do have it addressed in there that I signed this citation under promise to appear, and when I appeared at the court, there was no magistrate. And I'm sure if you listen to Eddie's show, you know that 543.006 states that the officer must have you sign the citation on a promise, to appear. The place specified in the notice to appear must be before a magistrate having jurisdiction of the offense who is in the municipality or county in which the offense is alleged to have been committed. A magistrate, not a judge. So I wanted to see the magistrate. They didn't show him. And the only other kind of hearing they could have, or what they appeared to order me to appear at, was an arraignment because they wanted to take a plea. The purpose of arraignment, 26.02. An arraignment takes place for the purpose of fixing his identity and hearing his plea. So they wanted to hold an arraignment hearing before a clerk to take my plea. Problem with that is, that was 26.02. 26.01 is what authorizes a judge to command you to appear at an arraignment hearing. In all felony cases after indictment and all misdemeanor misdemeanor case is punishable by imprisonment, there shall be an arraignment. Well, this wasn't punishable by imprisonment, so what was that hearing, Eddie?
Well, it was no hearing at all.
Yeah, how do they... you know of anything in the code that authorizes them, maybe in Section 45 that I'm not familiar with, that authorizes a judge to order me to appear to an arraignment hearing?
No, I do not. And the only thing I can find authorizing them to do anything even similar to that is for juveniles, which you're not. But the other problem is that the notice they sent you, which of course you're talking about now, does not comply at all with Chapter 23 on subpoenas or summons, which are the only valid means other than a warrant by which they can order you into court.
Yeah, it primarily doesn't tell me why I'm being ordered, so I can't determine if it's valid or not.
Yeah, it's not signed by the judge either, which it's required to be.
And I questioned them about that at the time because they handed me one, and I said, well, I can't take this. This is not signed. This is not a signed judicial order. I need one that's signed. Well, we'll send one to you. I said, well, you make sure you send it certified mail so I can prove it was sent. And the clerks thought this was funny because they knew I was going to kick the court's behinds. And when I went in Wednesday evening and apologized for missing the court at 9 a.m., they said, oh, we were so disappointed. We were looking forward to this. So anyway, I didn't show up for my hearing. And the dirty, rotten scoundrel, the prosecuting attorney, dismissed the case. And I had so planned on asking the bailiff to arrest him because the judge wasn't going to be there.
Yeah, not to mention anything he would have asked the witness would have been suborning perjury.
Yeah, well, the only thing we couldn't get to anything because he can't ask me any questions. He can't even talk to me until a judge has convened the hearing.
Well, he could. He could talk to you off the record as far as the case because you're acting as your own counsel.
Well, he can talk, but he can't do it under any official capacity.
Right.
And my complaint is if you want to have a meeting with me, you call me and question me as to my schedule so I can check my schedule, see if it's convenient for me to show up. But you don't get to order me to court to meet with you, and certainly the judge has no power to do that.
Yeah, so this kind of goes hand in hand with the new set of motions that I'm working up for the seminar material. A lot of the motions that are in the seminar material are going to be transferred over to just informational pages in a book, so to speak, and we're going to simplify the set of motions in the seminar material down to a handful instead of the number we've got, because we're going to take the same issue, but we're going to approach it from a different direction. And we're going to attempt to do this in a way that forces both the prosecutor and the court to admit they cannot meet the burden of proof. And when they cannot meet the burden of proof, going forward will be to their own detriment. And we've got to get them to a point where they have no choice but to acknowledge that. I think I figured out a way to do that, but we will see.
Good. This one got dismissed, but the chief of police knew that I had filed first-degree felony aggravated assault charges against the local district judge and criminal conspiracy against the Texas Ranger and the head of the Department of Public Safety, and it was before the grand jury at the time. And he already knew me and had some experience in the past. And I ran into him in the courthouse one day, and he said, "Hello, Mr. Kellner." He said, "What were you doing in Wichita Falls?" I said, "Oh, you know about that?" "Oh, yeah." "How'd you find out?" "Well, the chief of police called me, wanted to know if you were crazy." I said, "What you tell him?" "Yeah, he is. Don't screw with him. He knows his law." Hang on, Randy Kelton, Eddie Craig, Rule of Law Radio. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Look what we got. We asked for Christian. Wonder what I don't have the answer. We asked for Christian. Look what we got. And they don't have the answer.
Okay, we are back. Randy Kelton, Eddie Craig, Rule of Law Radio, and I was qualifying the fact that my ticket got thrown out. Don't expect these bigger jurisdictions to respond quite so effectively. But it's okay because all of this is setting them up. These information requests are very pointed, very specific, and for the most part, jurisdictions aren't going to be able to respond. Now, Fort Worth would be, and Dallas would be, because they're a city of more than 50,000. But they're not going to have this certification anyway. And that,
oh, no, wait. That's only one of the criteria, the population. The other requirement is it has to border 2 or more foreign states, or that it has to be on the Gulf of Mexico, bordering the Rio Grande or a territorial boundary with another country.
Now, this, okay. There was, let me, because that one, when I read it, it was stood out because it was by itself.
Yeah, that's 4.13C of the Administrative Code.
Certification of peace officers. The Department shows 644-101. The Department shall establish procedures including training for municipal police officers, deputies. A police officer of any of the following municipalities is eligible to apply for certification under this section. A municipality with a population of 50 or more, semicolon. Nothing else to that one.
Yeah, you got to look at the Administrative Code, but it is there. The Administrative Code says a lot any Rule 4.13 Title 37.
Okay, a municipality with a population of 25,000 or more, any part of which is located in a county with a population of 500,000 or more. A municipality with a population of less than 25,000, any part of which is located in a county with a population of 3.3 million. That contains or is adjacent to an international airport. I think that's the one you're referring to. A municipality with a population of at least 34,000 that is located in a county that borders 2 or more states. A municipality, any part of which is located in a county bordering the United Mexican States.
Okay, here. Let me read this to you here. This is Rule 4.13, and let me give you the entire site so you can dig through and find it in the Administrative Code. It is Title 37, Part 1, Chapter 4, Subchapter B, Rule 4.13, Subsection 4, or A4. And this is exactly how it reads. Municipal police officers from any of the Texas cities meeting the training and certification requirements contained in subsection B of this section and certified by the department may stop, enter, or detain on a highway or a port of entry within the municipality a motor vehicle subject to Transportation Code Chapter 644, the very chapter you're discussing.
Yes.
A municipality with a population of 50,000 or more, semicolon, just like you've got, right?
Yes.
B, a municipality with a population of 25,000 or more, any part of which is located in a county with a population of 500,000 or more. C, a municipality with a population of less than 25,000, any part of which is located in a county with a population of 3.3 million that contains or is adjacent to an international port. D, a municipality with a population of at least 34,000 that is located in a county that borders 2 or more states. E, a municipality any part of which is located in a county bordering the United Mexican States. F, a municipality with a population of less than 5,000 that is located adjacent to a bay connected to the Gulf of Mexico in a county adjacent to a county with a population greater than 3.3 million.
That's my favorite one.
Yeah, and this just goes on and on. But what you need to do is then go down to subsection B where it says training and certification requirements. And the first one it has is minimum standards. Minimum standards are as follows. Certain peace officers from the municipalities and counties specified in subsection A of this section before being certified to enforce this article must meet the standards detailed in this paragraph. A, successfully complete the North American Standard Roadside Inspection Course. B, successfully complete the Texas Interstate Roadside Inspection Course Part C if initial certification occurs on or before January 1, 2006, or if recertification is required under subsection C4 of this section. And C, participate in an on-the-job training program following the North American Standard Roadside Inspection Course with a certified officer and perform a minimum of 32 Level 1 inspections. These inspections should be completed as soon as practical, but not later than 6 months after course completion. Then you get into subsection 2 of B, dealing with hazardous materials, and 3, cargo tank specification, and 4, other bulk packaging, 5, passenger vehicles, 6, training provided by the department, meaning the Department of Public Safety, and 7, training provided by other training entities, and that covers the rest of it. So
that's enough.
Yeah, there's a ton of things that must occur before a municipal or county sheriff's officer is authorized to enforce the Transportation Code at all, which makes the statement in 543.001 about any peace officer misleading. That makes it vague and ambiguous because under the terms of the Administrative Code as we see them here, Only peace officers that meet these requirements could make the stops that are required under Subtitle C of the Transportation Code, all of the rules of the road moving violations. So when it says any peace officer, the inference logically can only mean any peace officer that is either A, expressly authorized by the Transportation Code, which is only those officers that are in the Department of Public Safety, or B, those officers that have been trained by the Department of Public Safety and certified in accordance with these provisions of the Administrative Code.
Yeah, and 543-008 said that any officer who violates this section is guilty of official misconduct and subject to removal from office. It appears the legislature took that pretty serious.
Yeah, if you enforce it wrong, you can be fired. Well, guess what? They are all enforcing it wrong. Not just in the fact that they're enforcing it all together, but they're enforcing it against the wrong class of people.
This is great fun. Okay, I need to go to my caller. I have a full board of callers today. Holy mackerel!
Yes, you do.
I'm going to go to them. And guys, we got a lot of callers, and I took up a bunch of the front end time, and it's only 2 hours today, so we're going to go relatively quickly. Let's go to Jeff in Mississippi because he's real quick. Hello, Mr. Jeff.
Hey, Randy. Thanks for having me on the show.
Glad to have you. What do you have for us today?
Okay, in a federal lawsuit, I am now starting on interrogatories.
Okay, you keep saying interrogatories. We talked earlier today on the phone. Think discovery as a whole.
Okay.
Think what will they not want to give you. In interrogatories, you generally only get about 25 questions. You need to check that because you're limited in the number of questions that you can ask, and you can't ask multi-part questions. So you need to look up the rules for interrogatories. You might look up objections concerning discovery. So you have questions, the interrogatories and admissions. That's an art form. Actually, all of discovery is an art form.
Yeah, and you may have a different number for each of those. Interrogatories versus admissions. They're considered separate things, and the rules are different for each one, and you're limited to a certain number of each one, but they're not necessarily the same. Now, the other problem you're going to have with doing those properly is do not request anything in an admission or an interrogatory that you can prove from anything else that you get through discovery. Don't waste them by being redundant.
Yeah, because they will object especially if it's something in public record, they'll object because you have equal access.
Got it.
Or if you've already got it, then they'll say you already have it or if it's filed in the case.
Okay.
Be real artful with your discovery. It can be your most powerful tool when carefully crafted.
Well, I've got two questions that are centered around the same item. My complaint for the defendants is against a university, and I listed the dean of the university and the director of student affairs of the university, and I listed the university itself. So that's three. The attorney represents all three of them. He wrote back that...
Okay, hang on.
Hang on, Jeff. We're about to go to break.
Randy Kelton, Eddie Craig, Rule of Law Radio. Our call-in number 512-646-1984. Don't call in yet. As soon as we finish with the caller, then you can call.
Forget a penny for your thoughts. The Pentagon is spending millions to develop artificial telepathy. I'll admit there may be military advantages to reading minds, but what does it mean for privacy? I'm Dr. Catherine Albrecht, and I'll tell you more in just a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
As a liberty-loving citizen, I'm often dismayed at how the government treats our privacy. But I've found solace in the freedom of my thoughts, at least so far. Discover Magazine reports the U.S. Army is developing a thought helmet that can read minds using artificial telepathy. The stated goal is to allow silent battlefield communications between soldiers. Trouble is, if it works for the military, you can be sure it's just a matter of time before regular people will be required to strap on a helmet and submit our thoughts to inspection too. After all, what's the problem if you have nothing to hide? I'm Dr. Catherine Albrecht, urging you to speak up and resist invasive technologies. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Yeah, Mr. Officer, you're taking the law in your hand. Won't you follow the law of the land? I don't understand. Your job is to protect and to serve, not beat and abuse. Officer, when you gonna stop abuse your power? When you gonna stop abuse your power?
Okay, we are back. Randy Kelton, Eddie Craig, Rule of Law Radio. Deborah has the night off, and we are talking to Jeff in Mississippi. Okay, Jeff, we do need to move quickly because I used up too much of our time. Okay.
Okay. I filed a complaint, listed 3 people. One attorney represents all 3 parties. Actually, the university is one party. That's a federal complaint. Federal Rules of Civil Procedure, Rule 26. The attorney's response, his motion to dismiss 12B6, one of his claims was that the dean of the college has moved away. He's no longer there. Therefore, Mr. Hill's listing him as a party is totally irrelevant and frivolous because we don't know where he's at. So when I send an interrogatory or, whatever discovery, who do I ask? Who will I ask what the address is for this missing dean?
Let me make a suggestion. As a matter of fact, I just hired a private investigator today. Send me this guy's name. We will find him. Muhaha. A litigant doesn't become irrelevant simply because the litigant can't be found.
Can I interject something here?
Yeah, absolutely.
Jeff, on the location where these charges were made, where you were living at the time, you've already said that location was not a part of the campus, either officially or territorially, correct?
Mm-hmm.
And you know that for a fact, correct?
Yes.
Then one of your admissions should be is to get them to admit up front, based upon an actual deed of the property, whether or not this property is in fact a legitimate property belonging to or attached to or under the direct supervision and jurisdiction of that university. Get that admission from them as no, it isn't, because that is proof positive the entire charge against you was baseless.
Mm-hmm. Okay.
But be artful in how you craft your questions.
Yeah, don't leave them a way of wiggling out of it by being ambiguous about something. Make sure that you cut off all the exits as easily as you can with the language, but without leaving other ways to get out.
What I was getting at are pawn moves. Is you ask them questions that sets a pawn in front of them, so that by the time you ask the critical question, every direction they want to move to, they've already answered a question that won't let them step in that direction.
Okay.
Yeah. If you want to see an example of how to do something like that, go to my blog, taooflaw, TAOOFLAW.wordpress.com, and find the article on there that deals with civil infractions, what to do if your state has them. At the bottom of that article are 7 specifically worded interrogatories that will work in any state where a transportation issue is a civil infraction. And based upon the way I asked those, each one builds upon the answer to the previous one. And each one asks the question in a way that there is only one way they can answer it. And that answer is in your favor.
Okay.
And so you want to craft your answers as Randy, or your questions for your interrogatories and admissions as much like that as possible.
Okay, got it. Okay, the second part of my question, which is the same question, it's just part B. Rule 26 makes it automatic that opposition supply simple information like addresses of parties. So when this attorney responded back with saying, well, we don't know where this dean's at, isn't he violating Rule 26 and can I jack him up?
No. Not if he really does not know and could not reasonably find out. What is this dean's name?
His name is Ray Wallace, and he's actually dean of a college in Kansas right now. So it's really easy to find him. I'm just not telling them that I know. I want them to struggle.
Well, it's very unlikely that one university doesn't know where a prior dean has gone to be a dean.
Exactly.
Because most of them would have had to send out letters of recommendation and things like that. So what you should be doing is requesting anything that also covers that aspect. Please provide me any letters of recommendation for this person to leave your university and go to some other university. Any notices provided by this dean that he was leaving your university, and any forwarding information that he was providing you, and so on and so forth.
That's what I want. Okay. You just answered my question. Thank you. I would have never thought of that.
Hey, anything that you can use to go through it, and you have a right to have through discovery, those are the things you want to be asking for. Those are the things that would point you in the direction you want to go, right?
Yes.
And this is the reason we have Eddie Craig on here, because he is such a fart smeller and a deep stinker. Good. And everybody says so.
Okay.
Almost daily.
That does it for me.
All right. Well, thanks for calling in, Jeff.
Thanks. Call you next week. Bye.
Thank you, Jeff. Now we're going to Andrew in Pennsylvania. Hello, Andrew.
How you doing? I need to give a little bit of an update in regards to my issue with the case in Arizona and how the courts seem to be deviating from procedure. I was expecting a call today from the courts. I had already paid the lawyer the money that was the fine money, and I was expecting a call from the courts to ask me a series of innocuous questions. The lawyer had called me a couple days before telling me what was going to be asked, but I didn't get the call when I expected it, and then the lawyer's office called me back and said the courts seem to be deviating from procedure. They're going to mail you, we're going to mail you something that you have to answer, like a checklist of questions, and they said something about you have to do it in front of an officer, and I asked them, okay, is there any way we can file some sort of a motion that the courts are deviating from procedure? And she said, no, this is kind of how it's done. So, this is kind of annoying because I tried using Eddie Craig's here for the traffic stop and it backfired. I kept my windows up and that was my mistake, but I went to jail and I filed your paperwork, Randy, your jurisprudence stuff, but then even after they sent my mother back the bail money, we thought everything was okay. Well, apparently not, because they prosecuted the case again. And I got a letter in the certified mail saying charges are being pressed against you. So you suggested to me get yourself an attorney, because if you try to fight right to travel going from Arizona to Pennsylvania, it's going to cost you too much money. It's not worth it. So here I am finding out they're going to deviate from procedure, and it's like my lawyers are telling me this is how it's done. I know.
Okay, hold on. How does the deviation from procedure affect your rights?
Well, they told me I basically waive all my rights because I filed a plea bargain to get one shot, the failure to ID, which is a total due process violation in of itself. You look at the statute, but
okay, we got that. Okay, hold on. What is there anything in this deviation from procedure that would go to a due process violation, or is it merely annoying?
I'd like to think it's both. It is annoying, but I like to think it's a due process violation. Not from Arizona. I don't know the rules of the court there, and I haven't had time to look at it yet.
Okay, what did they ask you? Did they ask you anything that would be inappropriate for you to answer?
Well, no, I didn't get that yet. The lawyers are going to send me the checklist of questions that the courts have given.
Okay, again, we get into, we have a lot of people in legal reform that want to fight the system. But Eddie I'm sure will agree with me. Pick your fights real careful. If you go in and raise a big stink about something that simply doesn't matter, you're really going to damage your credibility. And yes, some of the things they do can be annoying. They ordered me to show up at their court on a day at a time that was not convenient to me. But I showed up anyway because I had a better fight to fight. So, again, pick your fight real carefully. And make sure that you have a good claim and don't fight them just to be fighting them. They perceive you as much more dangerous if you sharpshoot them. You don't argue about the minor stuff and only sting them on the stuff they can't respond to. Hang on. Randy Kelton, Eddie Craig, Blue Law Radio. We'll be right back.
Easy.
Okay, we are back. Randy Kelton, Eddie Craig, Rule Law Radio, and we have Mr. Jeff from Maryland on with us, Mr. Jeff Sedgwick. Always a special guest because he always corrects me when I'm wrong, which I very often need. And we're going to finish up with Andrew. Okay, Andrew, they want you to fill out a document, and you have pled down. So you have pled. You don't have the document yet?
No, they're mailing it tomorrow.
Okay. When you get it, then we look at it and see if there's anything in there that's especially obnoxious, and I seriously doubt there will be.
Okay. And I also wanted to, well, since you have Eddie Craig on, would it be okay with you guys if I, just to set a few things straight, play a little game of Randy Kelton said A, Eddie Craig said B? I need to figure out who's right because you guys did tell me contradictory things, and I kind of want to address it right now. Is that okay with you?
Okay, go ahead.
Okay. First things first. After I filed your jurisprudence documents, Randy, that, like you told me to try to make it clear to the courts and the prosecutor, I know you violate all my rights and everything, and I want to sue you and all that, or let you know that I'm going to sue you. Shortly after that, my mother, who bailed me out of jail, got her money back, and you told me that's a very good indication they don't want to prosecute the case anymore. And so I assumed, okay, maybe I shouldn't have to worry about it anymore. Well, apparently not, because their computer system looked it up as a case that they could prosecute. So they did that. And when I brought that up with Eddie on his show, he was telling me, well, you should have looked researched into that to see if maybe it was a clerical error. Well, should I have? I mean, if you think about it, if the courts make an error, a clerical error, the last thing you want to do is research it, because then if you research, they get it wrong. The court's like, oh, we screwed up. Now we get to ask you to give us the money back and everything like that.
Okay, first thing, all you have to do to research the clerical error is to get them to send you whatever records are in that file. That will tell you exactly what paperwork was filed at any stage of the proceeding to get them to do what they did in the first place. All that's got to go into that file, whether it be a computerized file or an actual hard copy file. They'll have the documents. The second problem is one of the things I also told you, which by the fact that you entered a plea bargain with this tells me you didn't do, was to determine whether or not this was actually a criminal issue or a civil infraction issue in Arizona.
I did that.
Okay.
It was criminal.
Whoa, wait. This was speeding, right?
Okay.
No, failure to identify.
Well, that came, but why did they stop you, Andrew?
Because I was going over the posted limit.
It was speeding, right?
Yes.
That's what they used as the basis to pull you over, right?
Yes.
That is a civil infraction. The failure to ID is criminal, but if the initial arrest under false pretenses via that was illegal, that wouldn't have mattered, would it? In a civil infraction, there is no reasonable suspicion or articulable probable cause. A seizure without a warrant would be illegal under those conditions.
Okay, that's very true. The problem is getting the courts to rule according to law, which in traffic court,
that is exactly what those 7 interrogatories in the article on my blog are intended to do, to force the court and the prosecution to do exactly that, to make the determination that the initial stop by the officer was itself illegal. The statute cannot authorize a seizure without a warrant for anything less than a criminal act. It can't do it for civil.
Andrew, did you file those interrogatories?
The interrogatories were
the 7 specific questions on that at the bottom of that article I just talked about on my blog.
No. I never did that.
Okay.
What I did try to do.
Here's the rule.
Okay.
Follow all the steps. Everything about what you're doing is setting them up. Andrew, do you play chess?
Right. And I did.
No. That was a question. Do you play chess?
You say pick your moves wisely. Don't make it.
Okay.
Andrew, this is the problem. You're not listening to what you're being asked. You keep thinking of your own thing instead of answering what you're asked and doing what you're specifically directed to do. He asked you a specific question that only required a yes or no answer. Do you play chess or do you not play chess?
No.
Okay, this is where you're messing up on following directions. This is where most people mess up on following directions. You try to interpret what you're being told instead of listening to exactly what you're being told.
Okay. Andrew, have you ever heard of a game called Go?
No.
It's one of the oldest known games. It's a Japanese game, and you just put these stones on a board. And it's only got 2 rules. Is you have to put a stone on the intersection of 2 lines, and if your stone gets surrounded by other stones, it comes off the board. Oh, and you can't commit suicide. You can't put your stone in a place that's to be surrounded. Okay. So it's really open. And when it starts out, these guys just start putting stones all over the place. And they don't seem to make any sense. But as the game develops, they build up toward those original stones that were put out there, and all of a sudden you start bumping into these things and you can't get around them. Now that's a little simpler than chess. Chess is a little more complex. You might learn to play Go. When you're dealing with the courts, the first thing you have to do is lay out your plan and set your pawns out there so they're waiting for you to catch up with them. When you start out a chess game, there's, depending on how you're going to address the other side, there are places you need to put pawns. And when you put them out there, they can only move one space at a time. They can't do very, they can't back up. And they don't look like much, but they are the most powerful pieces on the board. If you don't get your pawns set up right, you're going to get trounced. So what Eddie's telling you about these steps, these are pawn moves. You're putting blocks in front of them that they can't get past. It's called collateral estoppel. Once they take a position, they can't change that position. So you ask them to take positions that box them in a corner. And frankly, it gets a lot more interesting when you think from that perspective. First, you have to know where they want to go and pay attention to how they get to where they want to be. And then back up and look at how can you put blocks in front of them that they have to try to get around. And you put a block in front of them so that the obvious way to get around it's going to run them into a trap. This is not checkers. This is not I hit you, you hit me back. If we're going to win this thing, we have to sit back and think, and we have to attend to the details. Devil's in the details. They just threw out my traffic case because it was clear to the chief of police that I was setting him up with those information requests. And he told me on the phone, Mr. Kelton, do you really think you'll get the ruling you want in this court? I said, of course not. I'll get my ruling in the federal court. And you could hear the anal sphincter squeeze tight all through the phone because that was my way of telling him, I'm just setting you guys up. So I don't care what you guys do. I'm just setting you up so when I get you to the place I want you to be, I can clobber you good. And he went to the city and told him, throw this guy out of here. He's setting us up. He's going to kick our behinds. If you pay attention to the details and you get the other side to realize this guy's setting us up, then they're going to be inclined to dismiss. If you react to what they do, and this call you made was about reacting to what they did. If you react to what they do, they can manipulate you easily. If you're going to react, make sure that you react in a way that they will not anticipate. And one of the best ways to react is to do nothing. If it's not important, if it doesn't matter, do nothing. They want you to fill it out, send it to them. If it has stuff in there that they don't have a right to, send it to them and then file a complaint against them for asking for it. But think strategically. Is that making sense? Eddie, have anything to rebut?
Yeah, it's just that I'm not trying to be mean to your heart on you, Andrew. I just want you to understand that you need to listen, not try to interpret or rewrite what the instructions are we're giving you. When I told you that you need to find out whether or not this was civil or criminal, I know the failure to ID is criminal, but the failure to ID is based upon which other action?
The original stop.
Which was based on a civil infraction, not a crime.
Yeah.
You
when
see?
Can you be charged with failure to ID?
It was.
Wait, hold on, Andrew. When can you be charged with failure to ID?
If you refuse to give your name, date of birth, and address after you've been lawfully arrested.
No, that's not when you can be charged. You can be charged with failure to ID if you fail to give your name and address after you have been arrested.
Lawfully arrested. And see, that's the thing. That right there is the key word in this. Lawfully arrested. An arrest without warrant for a civil infraction is not lawful. Period. No ifs, no ands, no buts. You could have shot both charges dead between the eyes by going after them with those 7 interrogatories.
And then you
That
get
was
to
my
file a
point.
challenge. Then you get to go for subject matter jurisdiction. You may be able to do that anyway.
Right. Now, what were you saying, Andrew?
I was not aware of those interrogatories at the time. I had no idea those existed on your side.
Yeah, well, I needed you to clarify what you were dealing with, civil or criminal, for the initial stop. But I didn't get that information. I got the criminal on the one, and I assumed criminal on the other till I found out different myself. All right, folks, we got to take a break. Andrew, hold on. We'll finish up on the other side. Call in number 512-646-1984. We'll be right back, so y'all hold on.
They want to chant down Babylon and burn down the whole nation. But them operate the land wrong. I'm going to say Republican and them a scratch, man. Tell them I'm a libertarian. Them say we want to lose, but we want to win. Come rock,
justice and peace. Chant love rule this time.
What we say?
Chant for our wars to cease. Chant down Babylon. Chant down Babylon. Chant for justice and chant for peace. Chant love rule this time. Chant for our wars to cease. Chant for our wars.
Okay, we are back. Randy Kelton, Eddie Craig, and Andrew. When you get that, whatever they want you to fill out, then look at it and see if there's anything in there that is particularly obnoxious or would tend to harm you in any way. And then call us back next week, and we'll go through it. But think of it from the perspective of pick your battles real careful.
Okay. And with that being said, the whole diversity jurisdiction thing, I did find the diversity jurisdiction thing, like Eddie suggested, since I wasn't in commerce and the federal constitution says state needs congressional approval to get contract with another state. Well, I eventually had to rescind that because after I told my lawyer that I did that, he said that he wouldn't be able to represent me, but eventually he said, no, I'll stay with you. You're being passionate. So, but the courts did send me a document back anyway saying your request.
Okay, wait, hold on. Have you filed a challenge to subject matter jurisdiction?
No.
That's what you should file. Okay. Hang on. Let them do whatever they do. Get the adjudication taken care of so your liberty is not challenged. And once that's done, if you still want to fight these guys, then you can file a challenge to subject matter jurisdiction. Subject matter jurisdiction can be challenged at any time, no matter how late in history. So don't risk going to jail. Liberty is most important. Clear up your liberty. Get this thing done. Once you got it done, now go back if you still want to fight this issue and hit them with a subject matter jurisdiction challenge. They will not know what to do with it. They'll screw it up. And then you get to beat them up all you want to, and you don't have to worry about your liberty being infringed. Okay?
Now, you said you're using an attorney, right?
Yeah.
Okay, ask your attorney why he is not challenging a warrantless seizure for a civil infraction with no criminal culpability or activity upon which probable cause could be based.
Okay, before you do that, let me make a suggestion. I'm not so prone to give fair warning. Your lawyer is learned counsel, and you know he's going to screw you. Because that's what they do. Wait till he screws it up, and then send him a tort letter. Then bar grieve him, and then sue him for malpractice. That'll be a whole lot more effective. If you sue him for malpractice, there's a good chance his insurance carrier will settle with you so they don't have to spend money on a lawyer fighting your case. Now, that's low down, dirty, rotten, but this is how we win these things. You may not win it into court.
Because, Randy, you told me back in the day when I talked about this lawyer, you said, well, I like him because he said I could take it up to the Supreme Court and they won't hear it. And now you're telling me he's going to screw you over. But and you also told me the diversity jurisdiction thing wouldn't work. And you said it was because something to the effect of the state has like the authority over the federal government in this regard, which kind of doesn't resonate with what Eddie told me. And that was the other thing that I kind of needed clarification about. Why would it work or not work? I got different answers.
Well, the federal Constitution specifically says that in any action where the state is a party, the court having original jurisdiction is the United States Supreme Court. That's written right into the federal Constitution. If the state of is the named entity as a party on any action, doesn't specify whether it's civil or criminal, it says any action, then the federal court has original jurisdiction. And I'm not talking any federal court, the United States Supreme Court.
Yeah. But I'm going to suggest that you are not sophisticated enough to sue the state in the Supreme. They'll beat you on procedure. You may well be sophisticated enough to sue your lawyer for not challenging subject matter jurisdiction. And, okay, in the end, it doesn't matter whether you have a valid case or not. Okay. If you're a lawyer, you can't say that kind of thing. But I'm not a lawyer. In the real world you and I live in, it's all about the money. The lawyer, your lawyer, one of the reasons to have a lawyer that most people don't understand is the lawyer has malpractice insurance. The malpractice insurance carrier, they don't want to get into a long, protracted legal battle. They only care about the money. You sue the lawyer, offer to settle with the insurance company, they're likely to settle so they don't have to pay all his attorney fees. Let's be practical. Set them up. Look for, when you go to a lawyer to sue somebody, he's going to look for deep pockets. So you get to do the same thing. Your lawyer has deep pockets through his malpractice and carries through your lawyer. It's a lot easier to sue your lawyer than to sue the state and the Fed. Let's be practical.
I can agree with that.
Okay, I do need to move along, Andrew. Call us next week when you have that document, and we'll talk about what they're trying to get you to answer.
Okay. Take care now.
Okay, thank you, Andrew. Okay, now we're going to go to Mauricio in Texas. Hello. Did I pronounce it right this time? Mauricio.
Yes, sir.
Randy, hold on before we get too deep with Mauricio. You got to give Jeff access to.
Right. Jeff in Maryland wants to address Jeff in Mississippi. Jeff in Mississippi, if you're still listening.
Really. We're getting to be regular exchangers of information here, Jeff and Jeff. And one of the things I want to make clear is that I know that you guys were under pressure at that time to get the show rolling and get into Q&A, and it may have slipped your mind to discuss this. But one of the things I want to be absolutely positive clear to your listening audience is that there is no way on God's green earth that admissions are the be-all to end-all. In fact, admissions can be dismissed in part or in total. So there's one area that Jeff in Mississippi could use to nail down his admission, admit or deny that you have jurisdiction over this particular piece of property at the time you exercise jurisdiction. Are you familiar with what that might be?
Okay. Was that a rhetorical question, or was that a question to us? Okay, was that a rhetorical question or a question to us?
No, I'm dead serious.
Yeah, okay. So, repeat the question.
All right. There is an area in discovery where you can pose a question that it doesn't matter if the admissions were thrown out or not. What area would that be? I'm heavily invested in Socrates' method of teaching. Come on, quickly.
I couldn't hear that. I've got Socrates, but that's all I got.
What area in discovery can you exercise that would nail down the admission, whether the admission was upheld in court or was thrown out? It wouldn't matter.
Jurisdiction.
What area can you exercise that would nail it?
The jurisdictional challenge.
Yeah. What area would, in discovery, would nail that down?
I'm not really sure what
you're meaning. I'm confused. I'm not sure what you're asking. You're going somewhere in particular, and I have no idea where that is.
Yeah, what areas of discovery are there? There are 4 of them. Name them.
Areas of discovery. You're talking about interrogatories, admissions, disclosures, productions.
I've never heard of disclosures.
I only know 3.
Production of documents.
Yeah, productions. But I only got 3. I got
okay.
Interrogatories, admissions, and productions.
Production of documents and deposition. 4 elements or 4 parts of discovery. So if you ask the question or pose the instructions to them to produce the documents that gave them authority over that particular piece of property, would that not stand solid against an admission that was...
Yeah, we spoke to that when we were talking to him about them showing that the property, Eddie asked a specific question. Did the property belong to the university or did it belong to somebody else? And he said, no,
he was talking in terms of the admissions. What I'm talking in terms of is don't overlook production of documents, because it doesn't really matter what they say in admissions. What documents show that they had jurisdiction?
Right, and that's what I told Jeff.
Who says and prove it?
Yeah, I told Jeff also, don't be redundant by asking something in admissions that you can get through other methods of discovery like document production.
Well,
in this case, that would have been a deed to the property.
Well, yeah, but he may actually have some sort of a contract as a school might. We don't know.
But he has a deed to the property. The deed to the property shows it doesn't belong. So I didn't go there with him because I knew he already had that.
Yes, but that is not the same as having it in writing from the school that says we have no documentation responsive to your inquiry. If they have no documents to show that they had jurisdiction, it wouldn't matter if the admission was there or not, would it?
Okay, the question, to ask for jurisdiction, that's not the question I would want to ask. I would want to be more artful.
Well, maybe so.
Yeah. How would the university demonstrate that the property was a part of the campus?
That
so that I,
because it could be a contract. Yeah.
No, wait, that won't work because I am a private citizen and I'm moving around in this environment. How could I have public notice that this particular piece of property is a part of the campus?
You wouldn't necessarily if it was under a contract. They
well,
need
if
to
I'm
disclose
if I'm walking around with a
their
pistol on my hip and I will cross a street, how do I have imputed knowledge that when I cross this street and step onto this side, that I've stepped onto campus property? I can't be held responsible for it unless I have a way to know. So how would I ask that question?
Because you want them to produce the documents because the documents would reveal whether or not it was public knowledge.
That's what I was getting at, how to ask that question in an artful way.
Wait a minute now, Randy. With production of documents, you don't have a question limit.
Randy Kelton, Eddie Craig, Rule of Law Radio. Our call-in number 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't fool me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see your plan. You put the fear in my pockets, took the money from my hand. Ain't gonna fool me with that same old trick again. Ain't gonna fool me.
Okay, we are back. Randy Kelton, Eddie Craig here with Jeff Sedgwick, and we're a little late coming in because Jeff Sedgwick on the break was cleaning my clock. Okay, and we're trying to figure out. Discovery is really an art form, and we're trying to figure out. Okay, this university leases this property from the owner, but they don't take ownership. So my question was, I'm just average Joe Blow, and I'm in a state where you have the right to open carry. So I'm trooping around. I got a pistol strapped on my hip, and I come to a stoplight, and I walk across the street. How do I know that I've just stepped onto campus property? What if if the university has leased this property? What duty do they have to take action to give me as a private citizen public notice that I'm stepping onto property where I cannot have that weapon? And then when I go to
the advantage with discovery, you use all three of the primary elements of discovery: production of documents, interrogatories, and admissions. You use them where they play off of each other. So if you lose something along the way, you got like the production shoring up interrogatories or shoring up your admissions. You use them in combination with each other to shore up your position. And is there a law that says that they have to disclose any lease agreements that they may have or any agency agreements that they may have that gives them jurisdiction? And if so, under what law? Or if there's a law that says that they don't have to, under what law? And that all goes to production of documents. And you do not have the limits on the number of requests for documents.
Wait a minute. I can't ask them to produce law because they're going to complain that I have equal access to the law.
No, what law they were using. You don't know which law that they were using.
Okay, what we're talking about here is how discovery is really an art form. And this is where we play chess. And discovery is powerful if you do it right. So we first figure out what they would have to do to give me as a private citizen public notice so that if I defied that public notice, they could establish mens reis, intent.
So,
if I don't know and I have no way of knowing, they can't establish intent. So what do they got to do to make it such that they could claim mens reis? Now, that's either actual notice or imputed notice. What do they have to do? Then I ask them if they've done that.
Right. And produce a documentation that shows that they did.
Exactly. And that's where I was going. If we ask, it's kind of a couple of steps removed from where we're at, so it's not as obvious what we're going for. And it's harder to argue against it if it's not directly interfering with your ability to defend yourself. Am I making sense, Jeff?
Kind of. Yeah. You're doing pretty good for Randy.
Yeah, I'm trying to find a really subtle backdoor. I'm looking for a pawn move.
You need to be careful about being subtle, because if you get too subtle, then the question becomes ambiguous and they can answer it any way they want.
Yeah, I understand that part. That's why I got to do my homework first and figure out what reasonably they would have to do to give me notice. Because Jeff, absolutely, when he went into this complex, he thought he was off campus. There was no mens rea.
So
he had no idea he was on campus property.
To not notice him?
Yeah, so that's what I want to see. What kind of notice would he have had to have? He could have imputed notice. That while he didn't have actual notice, he should have.
Based on what?
Well, a public filing. A notice in a newspaper. Or signs that says, this is campus property. I mean, that's the most logical and rational. No guns, campus property. I mean, there were none of that stuff.
Right.
So ask them, where do you put the signs giving notice that this particular property is campus property? If I look in the public record, I see it as belonging to this private individual. So where is the notice that would give me as a reasonable person notice that this is campus property?
Well, are they required to give notice?
That was if they're not statutorily, then in order to be able to claim mens reas, they would have to have it up there.
Yeah, you couldn't be accused of a violation of which there was no proper notice. That's a legal maximum.
All crimes are thought crimes. All these patriot mythology guys complain about thought crimes. All crimes are thought crimes. How was I holding my mind? How can you show that I intended to bring a weapon onto campus property? What notice did you give me to give me the opportunity to not bring a weapon here?
Right.
So where was the notice? I think that would be a really good question to ask.
Now, let's go a little step further, and I can't remember exactly how the language is, so forgive me on this. The attorney is representing the dean who subsequently has disappeared. Correct?
Yes.
And so he files a motion in to dismiss the attorney as counsel for such and so, because his client has disappeared and he doesn't know how to reach him, and ergo he's unable to serve.
Okay, but Jeff knows where he's at.
Well, it doesn't matter.
Okay.
This is about creating heartburn. Remember?
Yes, okay. Where are we going?
Pardon?
No, where are we going? Okay, the lawyer said he doesn't know what that's at.
Just remember, Randy's good at giving heartburn, not having it. Say it again, Jeff.
How can he be representing somebody who's disappeared and he can't get in touch with them?
How did he get power of attorney?
Yeah.
That's a good question.
No shit. Sorry.
Yeah, are you attempting to say that you represent a client with whom you have no communication?
Okay, I got chumped. You stumped the chump. I missed that one.
Okay. You're missing out on the fun, Randy.
Yes, I am.
Don't do that to yourself.
Okay, I did miss that one.
Okay, I can't remember what is it called. There's two things you can use to get rid of a judge. One, disqualify.
Yeah, recusal or disqualification.
Okay,
if you go and look at O'Connor's pleadings for federal court, you'll find it in there.
Disqualify. We're not talking about the judge here. We're talking about the lawyer that claims to be representing a client who's not representing that client. He can't be representing the client.
Not in claiming he doesn't know where
So the question is power of attorney for the lawyer from the client.
Uh-huh. But look at the O'Connor's pleadings for disqualifying attorneys. They give you a litany of different things you can check off and use.
Oh, wonderful. And I have O'Connor's pleadings, so I'll have a look at that.
Okay. Now, I think I've taken up enough
I knew I kept you around for a good reason. Okay, hang on. Going to break. Randy Kelton, Eddie Craig here with Jeff Cedric. We'll be right back.
Email is a convenient way to send and receive information, but it can also let advertisers snoop on you. Invisible web bugs and email messages could be monitoring your every click. I'm Dr. Catherine Albrecht, and I'll be back with more in just a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Web bugs, web beacons, pixel tags, and clear GIFs. They have many names, but these tiny invisible image files usually have one purpose only, to track your online behavior. Web bugs are commonly used on web pages, but they can also be embedded in email messages to report exactly when you open a message, the IP address of the computer that read the message, and whether you click on links contained in the message. The best way to fight a web bug invasion is to use a privacy-friendly email service that filters them out. You can also set your email client to block email message images or opt for a text-only email. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Trails. You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Yeah, and who you want to chip? Who you take me for? Free Tolly? Who you want to chip? Me no free Tolly. You can't chip me. I'm saying. Don't let them chip you in the morning, chip you in the evening. Put that chip in your body. And anyway you go computer ready. You can't hide me say from nobody. When me say, chip in your mom, chip in your daddy, chip in your grandpa and the granny, chip in me, chip in your baby, chip in your family, whole family, chip in your dog and they kept around we, chip in the beef and you still go EP.
Okay, Mauricio, Randy Kelton, Eddie Craig, Rule Law Radio. We're going to Mauricio in Texas. I'm sorry to hold you up, but Jeff always had good information, and that was excellent. I really like it when I get caught missing stuff. The problem with me missing stuff is I don't know I missed it. And Jeff really caught me flat-footed. That was wonderful. Okay, Mauricio, where are we at with you?
How you doing? Yeah, that Jeff's a real smart one. No problem there. Hi, Randy. How's it going again? Eddie, good talking to you again. Let me get Eddie caught up real quick. On May the 19th, I went in for my motions hearing. I went ahead and objected to having to argue or to challenge to make my argument to challenge the court's jurisdiction and ability to hear the case. And by doing it, the court knew full well that it was going to find me guilty no matter my motion and no matter what I did. She told me that she was sorry about that, that she thought that I felt that way, and that the only reason she had done the motion the same day was because the traveling issue. She didn't want me to have to travel back and forth so much. We went ahead and argued the motion. I argued the constitutional application of it and everything. Her response, and I think you'll find was quite ironic, she said that since she is a judge, she is a judicial officer, and she could not decide on a legislative issue. So because of that, she would have to deny my motion, and we would go straight to trial.
Whoa. What did she mean by she can't decide on a legislative issue?
Well, the argument of how it was enacted, the fact that, they didn't go through the procedures correctly to enact an emergency clause and so on and so forth, that all of that was based on legislation and their side of law, basically. And since she well, that's where she's incorrect. A challenge of unconstitutional acts by the legislature is a judicial determination, not a legislative one. So she's dead wrong there. That's the whole reason it's called a constitutional challenge. We don't go to the legislature and say, hey, we're raising a constitutional issue that you screwed up on. We go to the court and say this law is unenforceable because the legislature screwed up on it. So,
okay, Mauricio, what criminal accusation against the judge do you have now? Okay, I'm being Jeff Sedgwick here. I'm asking a question that you don't know where I'm going. 39.03 Texas Penal Code. If a public official fails to perform a duty he's required to perform and in the process denies a citizen full free access to or enjoyment of rights, that's a crime in the state of Texas. Misfeasance in office. This judge told you this wasn't her job, when in fact it was her job to make this determination. She told you it was the place of the legislature to make that, and it was hers. That's misfeasance in office. It's official oppressions, Class A misdemeanor in the state of Texas.
One thing I did forget to mention is during the motions hearing, the original judge, Larry Lawrence is his name, Larry Lawrence, he was sitting in the audience. And
Wait a minute. The judge's name is Lawrence?
Larry Lawrence, yeah.
No, Larry short for, there has to be something wrong with that.
I wish I was joking. But he's Precinct 3, Justice of the Peace, out of Nueces County.
Okay, when you say original judge, explain that.
It is his courtroom, supposedly. He was the one that I had the little altercation during the arraignment when I was challenging subject matter jurisdiction there at arm's length of the court. And
Okay, stop for a second, Mauricio. You said arraignment. Write down 27.01, 27.02. Texas Code of Criminal Procedure. Write that down. Look it up later. Okay, go ahead.
Okay, I'm going to get all this from the archive. That way we can kind of speed along this. Where was I? Oh, yeah. He was the one that after he told me that he didn't, because he said that he wasn't there playing word games with me. And I told him that if anyone was playing word games, it was the state and I was merely playing by the rules. He pulled out the other.
Okay, hold on, Mauricio. Will you move the mic down by your chin a little bit?
Sure, how's that?
You're kind of distorting the mic a little bit. I'm having trouble understanding you.
I apologize. I'm a little excited, too.
Okay, that's better. Go ahead.
All right, sorry about that. Okay, long story short, he basically ended up, after I told him that 2 citations he was trying to enact that were 4 years old, that they needed to be thrown out because of statute of limitations, that's when he slammed his hand down, said he didn't care what I thought. And that's when I told him that I was going to be polite, and instead of directly recusing him, I'm going to ask him to disqualify himself, or directly, vice versa. You get what I'm saying?
Yeah.
That's when he gets up screaming to follow him down the hallway. He's calling the constables and tells them that if I get in my car, I'm to be arrested.
Wait a minute. Hold on. The judge raised his voice to you?
Oh, he walked right in front. He came down from behind the bench, stood in front of me, pointed directly in my face with his finger, and told me to follow him. We walked down the hallway, out the regular entrance, and he's screaming at the top of his lungs, red in the face, with his hands in the air, shaking, both hands, calling for all available constables.
Charge him with official oppression. Let him explain that to a grand jury.
Okay, that's when the 3 constables come out, and they start hounding me. I asked them if I'm under arrest. They said no. I walked away, came back after a couple of minutes. 3 of them stayed there, told me that they knew what I was trying to do.
Okay, hold on. Did any one of those constables touch you?
Yes, at the beginning, but I don't have it in recording because
you don't need it in recording. Did a constable put his hand on you?
Well, they were chest bumping me. They were in my face yelling at me that what did I do to piss off?
Okay, you may not have recorded it, but the security cameras in the courthouse did.
Okay, here's it. Eddie, will you quote to him 2202 B2A Texas Penal Code? I know you know it.
Official or aggravated assault.
Exactly.
A person who is a public servant while displaying a deadly weapon commits simple assault. It is a first-degree felony aggravated assault.
Yeah, let me explain how it goes. If a person commits simple assault, as defined by 2201 Texas Penal Code, and the person is prominently displaying a deadly weapon, that's a felony of the 2nd degree, unless the person is a public official acting under the color, meaning pretense, of an official capacity, then it is a felony of the first degree. You all should have been in the Senate subcommittee hearing when Eddie landed on the subcommittee with that statute. There was a prosecutor from Houston who claimed that these officers who kicked and stomped this 16-year-old, 120-pound boy for a minute and 20 seconds after he stopped, laid down on his face, and gave up. And this prosecutor told the subcommittee the only thing he could charge them with was with official oppression.
Which at that time was only a Class B.
Yeah, and listening to Eddie read them the riot act was just incredible on 2202 B2A Texas Penal Code. Our legislature said, when you as a public official strap that pistol on your hip, that is an incredibly big deal. If you exert or purport to exert an authority you do not expressly have while you're wearing that loaded pistol, and you commit simple assault as defined by 2201 Texas Penal Code, first-degree felony, 20 to life. Charge the bailiffs, charge the judge with first-degree felony aggravated assault. I just charged my district judge first-degree felony aggravated assault because he had a bailiff touched.
Easy.
Some things I realize fully. Somebody's on a police, a policeman. Somebody's on a police, a bully. There's always a room at the top of the hill.
Okay, we are back. Randy Kelton, Rule of Law Radio. Mauricio, you understand that while on the one hand you are a defendant, on the other hand, when you walk into that facility, there are a lot of public officials there, and all those public officials are public servants. They're the servants, you're the master. So you have two duties there. One, you have a duty to adjudicate your issue before the court, but you have another duty to act as the master over the servant. And if one of the servants put a hand on you in order to prevent you from testifying before a court, I read that first as witness tampering, potentially as 3605, potentially obstruction of justice 3606, and first-degree felony aggravated assault 2202 B2A, but you don't file it against the bailiff because the bailiff was acting in good faith reliance on competent authority, the judge. You file against the judge.
I'll have to get some sort of open records to find the video to see for a fact if they did. But it was such a blur with the adrenaline, the way that they were rushing me. I'm more than certain that there was at least a chest butt in there. But, yes, I ended up spending over an hour outside on the court steps waiting for them to leave me alone so I could get in my automobile and leave. That was during the arraignment. During the trial and the motion hearing, that judge, had stepped down, and another judge had came in. Her name is Janice K. Stoner, and he was sitting in the audience area during the whole time. And whenever they would leave, the judge would take off, the two prosecutors would get up and leave through that door, and he would get up and leave through that door as well. During the motion, or during the trial itself, I even got the prosecutor to admit that.
Okay, wait, stop. You're saying that the judge sitting in the gallery went through the same door as the presiding judge?
Exactly.
You have reason to believe there was some kind of a conversation back there?
More than certain. They were talking on the way out.
About anything relating to the case or the court procedure surrounding your case?
That I cannot say yes or no.
But you have good reason to believe that is the case?
More than likely, yes. For him to be sitting in the office for her
when you're filing a criminal accusation, you file on, this is what the complaint says. I have reason to believe and do believe. It does not require best witness information. It can be hearsay. You have reason to believe and do believe that this judge that was sitting in the gallery went back and had an ex parte communication with the presiding judge, an inappropriate communication, in order to influence that judge to rule against you. Good thing about a criminal accusation is you don't have to prove it. It's enough to make it.
I ended up staying after everybody had left because there was a constable outside, and I saw the prosecutors and the other judge leave while Larry stayed in his office. That was after I was found guilty on the trial. Now, in the interest of time, let me speed things up because I did get them on record where they said that they were not transportation and commerce was not enacted. That's when I objected, asking for a divert verdict, stating that the case never, they admitted in open court that they never intended to apply the transportation code to the allegation, but then they could not allege an act in the code and deny the application of the code at the same time. Every time I did that, they were denied. Guilty. Okay, fine. Tomorrow is my last day to turn in my notice for appeal, which, if you could please send me a sample, I still haven't been able to find one that is sufficient. Secondly, I don't have the money for the bond.
Okay. When you ask for the notice of appeal in a Class C misdemeanor case, the notice of appeal has an affidavit of inability to pay. Now, inability to pay does not mean that you don't have any money or any funds. Inability to pay means that in paying this amount, it would cause an unreasonable hardship. So go in, fill out the inability to pay portion affidavit, and file your appeal. And then you can argue over inability to pay. But get that filed so you got it in within the time limit.
Do you know where I can find a sample of that?
You go to the clerk, to the court, they'll give you one. They've got their own forms.
Okay. How about the sample for the notice of appeal?
Wait, I couldn't understand you.
How about a good, reliable sample for the notice of appeal?
Oh, all a notice of appeal is I hereby give notice to the court of my intent to appeal. That's it.
Yeah, it's not in the form of a motion or anything else.
No. When you go to the court, ask them for an appeal form. They'll give you the form. It has the appeal and the affidavit of inability to pay. They're all in one document.
Okay.
Yeah, they'll give it to you. The important part is you get that in within the time limit. Now, if they object to it or if they disagree with it, that's okay. But your time limit is met. That's why I tell people, always get something in, even if it's crap, because you can amend it later. As long as you get it in within the time limit, then the clock stops.
Gotcha. And tomorrow the clock ends on Sunday, but tomorrow would be the last day, and they close at noon tomorrow. So I'm gonna go.
The last or first day cannot begin on any partial day, holiday, or weekend. When you're counting days, they cannot begin or end on a partial day, a weekend, or a holiday.
Okay, because the calendar started on the 19th, and if I went 10 executive days, it would end on Sunday. But by what you're saying, it would end on Tuesday.
Is Monday a holiday?
Exactly. Yes, it's Memorial Day.
Okay, then yes, it would end on Tuesday.
It's on Wednesday, Thursday.
No, Tuesday.
No, it would be Tuesday. If it would have ended on Sunday for calendar days, now it would end on Tuesday since Sunday is a weekend and Monday is a holiday.
Okay. Gotcha.
Yeah. You can't go in Monday because nobody's there.
Okay.
Or Sunday. So that's why it moves forward. Make sure you get in the time limit. Even if you give them crap, it don't make any difference. As long as you're within the time limit. Steve Skidmore came to me 2 days before an eviction hearing. He wanted a lawsuit. I went on the internet, pulled down a bunch of junk, stuck it together, filed it. They threw out the eviction hearing. It went to the district court, and I'm sorry, I got interrupted. It was a big boom out here. We must have a big storm coming. Anyway, the opposing counsel said, Your Honor, this pleading is a piece of crap. And the judge, about 30 days later, responded and said, yeah, it is a piece of crap. Dismissed without prejudice. Fix it. So we refiled it. The guy came back and said, it's another piece of crap. And the judge said, yeah, it is. Fix it again. So we filed a third one. Third one took. But that was 90 days later. Point is, get something in. Don't worry about getting it perfect. Just get something in there. So get something in Tuesday to make sure you're within the time limit. Or even tomorrow wouldn't hurt.
Right. I'm going to go tomorrow. And just for further notes again, ask them for their form for inability to pay, right?
Yes.
Gotcha. All righty.
And that'll get the time limit covered. Now you're good.
Perfect. That was
and in this case, an appeal is trial de novo, so you don't have to appeal based on error. Then you prepare for the county court, which the judge there will necessarily be a lawyer, and he's elected. It's a whole different animal. You get him facts and law, and he's more likely to rule in your favor.
Perfect. Now that I've got that done with, thank you so much on that, because that was my big worry. We can go back to the trial. She also turned in 4 case logs stating that her argument that the argument of commerce and transportation does apply to the average person. And I have those case logs here, and I'll try to get up there Sunday, Eddie. That way you can see what you put in.
Okay.
But sorry.
Okay.
Don't worry about this court. This court essentially doesn't matter because you'll replete everything before the county. For the counties where you need to have all your ducks in a row. Because now you got a real judge. And keep in mind, your only purpose is to set the record for appeal. You don't care what he rules, you're just setting the record.
That's it. Well, thank you, guys. Thank you for your time, man.
Okay, and thank you, and we are out of time. I am sorry, Charles and Eric. If you guys will call in tomorrow, I will pull you up first. Make sure, even if you get in a little later, I'll move you up. I apologize that you were on so long and we didn't get to you, but we'll definitely get to you tomorrow. Thank you all for listening, and thank you, Eddie, for producing for us tonight and giving us your valuable insight and a bit of comic relief.
Yeah, that too.
But we'll be back tomorrow. Thank you all for listening, and good night.
Dangerous.